Is there an onus, a burden upon the defense or the prosecution to determine lawfulness of this demonstration in the context of this Carter application?
The burden is always on the prosecution to prove that a criminal offense was committed. Everybody who's charged is presumed they've done nothing wrong, and it's for the Crown to show otherwise throughout. So I mean, at this stage, they simply have to point to some evidence that there was an agreement to engage in some sort of unlawful activity, but the onus is still theirs.
Or lawful until it's not.
An assembly is lawful until it becomes unlawful, and that's indicated in the criminal code.
Robert Krychek reporting for Rebel News here in Ottawa, Ontario, at the conclusion of day 32 of the trial of Tamara Lich and Chris Barber. The two defendants are being charged with a series of crimes related to their roles as organizers of the Freedom Convoy of 2022, a peaceful demonstration here in downtown Ottawa in opposition to what I always refer to as the COVID-19 enterprise. Government-issued decrees, edicts, mandates, lockdowns, ostensibly to address public health in the context of COVID-19. The day's proceedings were primarily consumed with this ongoing dispute over a Carter application, which was explained in previous videos. Please check our reports from earlier this week to get that explained, although I will review that again today. And we were also fortunate enough to briefly speak with Diane Magus, lawyer for Chris Barber, and Eric Granger, counsel for Tamara Lich, about some of what happened today. Also, Adam from the Democracy Fund will share some legal insights with us. But before we get to that, I want to remind you folks that we're not beholden to the federal government, and we depend on our viewers' financial support to continue these in-the-field reports. So please help us out at tamaratrial.com and stay up to date with our ongoing reports. One of the primary bones of contention between the prosecution and defense teams in the context of this broader dispute over this Carter application is whether or not the Freedom Convoy was a lawful protest. The Crown is contending that the Freedom Convoy was an unlawful demonstration. And if it's able to persuade the judge that the Freedom Convoy was unlawful, then both Tamara Lich and Chris Barber, as organizers of this protest, can be characterized as co-conspirators furthering a criminal act. And of course, the defense is taking the opposite position, stating that the Freedom Convoy is broadly a lawful protest and also not even a uniform or homogeneous protest. Moreover, the defense has already acknowledged in admissions submitted, I think at the beginning of this trial, that there were certain people at certain times in the context of the Freedom Convoy that had committed mischief, that had committed intimidation, that had committed obstruction of police, but that this was not done by the defendants and was not done at the behest of or due to counseling from the defendants. Now, in order to resolve this dispute over whether or not the demonstration and protest is to be determined lawful or unlawful, the prosecution said yesterday during the 31st day of the trial that the defense teams should submit applications to the judge to convince her, to persuade her, to have her determine the lawfulness of the protests. At that moment, it jumped out at me that this is an inversion of the presumption of innocence. It is not for the defense to prove that what it was involved in or what it did was innocent. It is up to the Crown to determine guilt. So if the Crown wants to have a preemptive decision made via separate application by the judge over the lawfulness or unlawfulness of this protest, it should be done by the prosecution itself. In other words, the Crown should submit an application of its own to persuade the judge and make a ruling or determination over the lawfulness or unlawfulness of this protest. So what is a Carter application? I'm glad you asked, as I will explain it. A Carter application is an attempt to pursue a submission by the Crown to apply a framework of conspiracy to the trial. So if a Carter application is accepted by a judge or jury, depending on the type of trial, It allows for the attribution of incriminating evidence against one defendant to be applied to another. It assumes that any crime that is deemed to have been committed by one defendant was committed towards the pursuit, the furtherance of some endpoint crime. Some conspiracy or agreement between the defendants is interpreted as a backdrop against which all of this analysis takes place. Now, why is this interesting or important or relevant in the context of this trial of Tamara Lich and Chris Barber? It's because Tamara Lich's name has come up so infrequently, so rarely in the context of the evidence presented by the Crown, both in the form of witnesses and videos. I can count probably on one hand how many times I've heard Tamara Lich's name come up in the evidence presented by the Crown. At one point, Tamara Lich even sort of joked to me that this trial is turning into the Chris Barber show. Further, none of the witnesses who were invited by the Crown to testify had any dealings with Tamara Lich in the context of the Freedom Convoy. So, given this background of the rarity and infrequency of Tamara Lich's featuring in the evidence presented by the Crown must have this Carter application accepted by the judge in order to rope her in with evidence that it argues, that it views and interprets as incriminating against Chris Barber. If they are unsuccessful in persuading the judge to accept this Carter application, it will be very difficult to have anything meaningful applied to Tamara Lich. So, Eric, the timing of the resolution of this Carter application dispute, not to be specific or have you divulge anything in terms of your defense strategy, but in a general sense, does it affect the way a defense proceeds with its strategy if it's resolved now as opposed to at the end of the trial, which you said earlier was more typical?
Oh, absolutely. The whole point of trying to argue this now is this is evidence the Crown seeks to use against our client. And if it gets resolved in our favor now, then that's evidence we don't need to worry about going forward. We don't need to consider going forward in any event. If it's resolved not in our favor, then we know, okay, that's evidence the Crown can use at the end of the case, and we'll have to deal with it accordingly.
So we have Diane Magus, defense attorney for Chris Barber. Now, Diane, you were making this distinction towards the end of proceedings. You were recalling what was a previous judgment, right? Beaufay, I think it was. It's like French surname. And you were stating that a protest is peaceful until it's not. Or lawful until it's not.
An assembly is lawful until it becomes unlawful. And that's indicated in the criminal code.
Okay, so as far as a peaceful demonstration versus an unlawful demonstration, I guess this distinction shouldn't be made because they're not synonymous to begin with, right? Like peaceful and lawful are not necessarily one and the same.
That's correct. But you need at least a peaceful demonstration to be able to be lawful, right? But there's other reason why a demonstration could become unlawful. For example, if there's laws that are broken, other than peaceful, right? Like if, for example, there's criminal code offenses, property damage, mischief, and so on, it may not be violent, but it may still be unlawful because certain section of the code were broken, for example.
Gotcha. So I'm here with Adam from the Democracy Fund. Now, Adam, we're going to talk about a couple of arguments made by the prosecution that are being challenged by Eric Granger, defense attorney for Tamara Lich, in the context of this Carter application. So the first one was this argument over the alleged homogeneity of the Freedom Convoy. Why don't you tell us why that was interesting and what Granger's saying back to that?
Sure. So the Crown wants to show that the protest was singular and ubiquitous. There was a unity there, that Barber had a large amount of control over the people at the protest. What Granger is contending in his submissions is that, and what the evidence has shown, and I think Perkins McVeigh is live to this as well based on her comments, is that there were multiple different protesters there for multiple different reasons, and Barber did not have control over all of the people there. And why is this important as it relates to the Carter application? Well, the Carter application needs to show a common unlawful design, a common unlawful agreement that Lich and Barber engaged in. This is what the Crown needs to establish for this Carter application. It makes it difficult for them to make that argument if there were numerous people in Ottawa for numerous different reasons. It certainly puts the Crown on a back foot when they approach that issue.
I'm here with Brian Duty. It's a fantastic name, by the way. And Brian is with the JCCF, the
outside counsel.
Okay, and basically you've been in for proceedings for a couple of days, and we were speaking earlier about speculating on costs and dedication of resources for this trial of Tamara, Lich, and Chris Barber. Maybe you can share with our audience some things that you were contemplating when we had that discussion.
Well, when trial dates are set, counsel is asked to try and estimate the number of days that a trial will be. I think this trial is now in day 32, and that's way beyond what the original trial estimate was. So there are, I think each additional date of trial incurs additional costs.
Sure.
To run a courtroom for a day, you need to have 2 clerks and a presiding judge. And in the case of Barber and Lich, there are 2 full-time Crown prosecutors and 5 lawyers for the defendants. And so just in terms of multiplying that, by 32, you're getting into some serious, court resources that are being set aside to deal with this one trial. So at 32 days, I would say it's a very lengthy trial.
Now, there's something I want to ask Diane Vegas, but I'll ask you because it's actually occurring to me at the moment. It's sort of the distinction between, if there is one, peaceful versus lawful. So that was something that was maintained by both Radcliffe and Westshire yesterday. Is that accurate? I mean, is a peaceful demonstration by definition lawful, or are there circumstances where that's not the case?
I mean, that's a very good question. Other than to say that obviously peaceful and lawful are 2 different words. Certainly when one thinks of such a thing as a peaceful demonstration, one thinks of something that's likely going on lawfully, but could one, in the infinite permutations and combinations out there, come up with a way that you could be peaceful but somehow otherwise breaking the law? I wouldn't foreclose that possibility. I mean, peaceful is not synonymous with lawful, but certainly, as we heard in the evidence in this case, peaceful and lawful were often or at times used together as to describe the nature of what was happening.
I guess with respect to the comments that Perkins McVeigh also made in the submissions of Granger, as well as the Crown, this commonality of purpose, right? So the Crown is saying that, perhaps there were different factions, but they still had an underlying commonality of purpose. They were there for, largely speaking, the same reasons. Granger's position and defense's position to that point is that that's fine. People can be here for the same reason, but also not be part of the same group.
Right. Okay.
And this is where he's again, that sort of detracts from the Crown's position, which is that, Mr. Barber had a lot of control or complete control over this convoy.
There's a procedure that leads to the trial that is supposed to ensure that defense counsel and the Crown have a dialogue, and there's a judicial pretrial held, which is between the defense counsel and the Crown counsel in front of a judge to determine the estimated number of days required. So I'm just saying, in terms of this particular case, where we're at right now has gone way beyond the initial estimate. So, and that has an effect on court resources available. When one courtroom is being used for 32 days, it can't be used for other matters.
Right. Now, as far as the onus, is there an onus, a burden upon the defense or the prosecution to determine lawfulness of this demonstration, the context of this Carter application?
The burden is always on the prosecution to prove that a criminal offense was committed. Everybody whose charge is presumed they've done nothing wrong, and it's for the Crown to show otherwise throughout. So I mean, at this stage, they simply have to point to some evidence that there was an agreement to engage in some sort of unlawful activity, but the onus is still theirs.
Hey, why don't you tell our audience what Granger was arguing in this regard with respect to the Carter application today?
Sure. So the Crown, in their submissions, was suggesting that they wanted defense to bring a charter application, essentially showing that the protest at large was lawful. Right. Granger in his submissions today said, well, that's not our job. Our job is not here to show that the protest was lawful. That's a reverse onus. That's putting us in the position of saying, OK, our clients acted lawfully. The onus remains squarely on the Crown to show that the behavior of the accused was unlawful. And so this is where that back and forth stemmed from.
In your experience as a lawyer now for at least a couple of years, would you say that the average wait time for a trial has been upped over time? The reason I ask is because in general, there's this degradation of so-called public services. It's harder to get a doctor, for example, in Ottawa than ever before. Wait times for all sorts of medical services are upping and upping and upping over the years. And I'm wondering if that sort of degradation of access to service is something that's also being noticed in the context of the judicial system. Does it take longer to get a courtroom, longer to get a judge, longer to get trials completed than it was, let's say, in years prior?
That is an interesting question. I believe in the process of having a dialogue between the Crown and the Crown lawyer and the defense lawyer, having a real dialogue about how long the trial is going to take, what disclosure is going to be provided. And when there is that dialogue between the defense and the Crown, I think you can go before the judicial pretrial judge and you can figure out together an estimate that's realistic. I guess my concern is that, I think we're in a situation, where, obviously I think the original estimates were not accurate.
This trial will resume next Thursday, December 7th, for one day of proceedings. And at that point, presumably they will set out future dates. So we sort of expect that to be somewhere in January based on what the judge has said today about her availability and also from the prosecution and defense. So stay tuned for more reports. Dear Rebel News audience, we need your financial support to continue producing these in-the-field reports, this unique journalism that can't be done anywhere else. So please visit tamaratrial.com to contribute to our operational costs and stay up to date with our ongoing reports.